Hi, I'm Andy Stentiford. I'm a European and UK patent attorney. I've been doing patents for more than 20 years now. So I've worked in a variety of roles. I've worked in private practice, essentially in a law firm. I've also worked in-house at multinational companies as a patent attorney and also as head of IP. Now I'm working with Lightbringer, an AI-enabled company for helping people protecting their technology with patents. And I'm here today to answer some of your questions, which have often come up through my career and are still questions we see every day. So hopefully I can give you some insight on a bit more insight into patents. Here's a really important question. Is brainstorming with an AI tool a public disclosure that hurts patentability? Really important in this day and age, given how LLMs and ChatGPT is becoming used every day. So one answer, it depends on your plan. On the base level of ChatGPT, often the input you're putting into these LLMs is not confidential, and also they're using it to train the LLMs. So it's really not a good idea to put technology, details of an invention into an LLM if you're then planning to file a patent application. The other thing to think about, some of the plans with LLMs, the pro plans, the enterprise plans, they will have confidentiality clauses in them, but you still need to make sure that that material is not being used to train the AI models. The consideration here is, well, if they use your input to train the AI model, then maybe further down the timeline, the AI will spit out your invention. It may not happen, but the thing is, you need to take the precaution, and you need to make sure that you're not making a public disclosure with one of these AI tools. I think here at Lightbringer, obviously we're an AI-enabled company, and we do have data security, SOC 2 qualification, and also all the information is confidential and, of course, not being used to train the LLMs. Can I patent an idea, or do I need a prototype? It's a great question. So you can patent an idea without the prototype. That's fine. The patenting system doesn't care if you've got a prototype or not. But one of the things that's essential to getting a patent granted is giving enough detail that someone else can make your invention. The jargon in Europe is called enablement. So do you have enough details that someone else can make the invention? And that might mean that to get to that point, you might actually have to make a prototype anyway. And often making a prototype can give you a better understanding of your invention. But essentially, no. And that means you can extrapolate ideas and you can patent slightly more abstract ideas. But you still need to give at least one example of how it would work in practice. What does patent pending actually mean? So when the process of getting a patent is a journey, and it starts with you writing a patent application, drafting, I think patent attorneys call it, and then you have to file the patent application at the patent office. And at that point, a patent examiner will look at it and review it and say, yes, you have an invention, and I'll grant you a patent, or no, I don't agree. But at the point of filing the patent application, and you have a filing date and a patent application number, then your patent application is pending. So you can say patent pending. And your patent will be pending until either a patent examiner grants it and allows your patent application, or he says no and it becomes withdrawn, but let's not go there. Once it's granted, you have a granted patent. And then you can use your patent to enforce it if you needed to. But essentially, you can say patent pending after you filed it. Will posting on Kickstarter or social media or a website kill my patent rights? Where do you want to patent, and when did you publish? So let's dig into it a bit. So one of the requirements for getting a granted patent is it has to be novel or new to non-patent people. And what does that mean? It means that it hasn't been made available to anyone in the world. So that's published in a patent, or published on a website or Kickstarter. So if you publish on Kickstarter or social media before you file the patent, then that could, in theory, affect your rights to getting a patent. Now, we need to reflect on there are slightly different rules in different parts of the world. So in somewhere like the US, they have a grace period where the inventor, if they've made that disclosure, that won't be counted against them. But that's not the rule across the world. So if you rely on the US rules, it might mean you can't get a patent elsewhere. So best practice is to file a patent first, then tell the world. You post on Kickstarter or social media or website. But you can rely on the grace period, but it may affect rights in other parts of the world. So here's another question: should I patent or should I go open source instead? It's a great question. It goes to the core of why a patent. And so the real question is, do you want to control your proprietary technology? Would you be upset if someone else used your proprietary technology that you spent resources, time and effort acquiring? And so, and if the answer is no, I don't mind, then okay, perhaps a patent isn't the right tool here. But if it goes to the core of your business and basically makes or breaks your business or perhaps your USP, then patent is clearly a way that you can exercise control over that proprietary technology. I would say, obviously I'm a patent attorney, but if you're not sure, but the thing is, it could be relevant, I would say it's better to probably try and patent it, and then you can always exercise that control. You can decide not to exercise that control if you're deciding that you want to let others use it. You can always license that technology. Can I sell or license my patent? How do I find buyers or licensees? I can answer one half of that question easily. The second half is a bit harder. So the first thing to say about a patent is that it's an asset. Like real estate or physical assets, you can buy or sell them. It's the same with a patent. You can own a patent and you can sell it or buy it. So, and that's very much that process is contractual, and two parties come together and agree a price, and then you sign an assignment agreement, and then the ownership will transfer. And you may record that ownership at the patent office. You can also own the patent and keep the rights to the patent, but you can also let someone else use the technology covered by that patent, and that's called a patent license. The licensee is authorized to use that patented technology, and they know that they're not going to infringe the patent, and they're paying, typically a licensee will pay the patent owner some money, also known as a royalty, and royalties come in different shapes and sizes, and often contractual terms will dictate how that's done. The licenses can be arranged in different ways. So you can license a patent geographically. So you can license, so for example, North America and Europe might be different licensees under a patent if there are patents covering those different territories. You can have many licenses to a patent, so non-exclusive licensees, or you could just have one, an exclusive licensee. And if you're an exclusive licensee, that's going to cost more than if you're a non-exclusive licensee. And how do you find buyers or licensees? I mean, that's the hard question. I mean, it will depend on the marketplace and the commercials. So one example, if there is, you might be able to identify interest in the patent if someone, for example, has tried to oppose your patent in Europe, for example, and has tried to apply to the patent office to say, to revoke the patent. If you're successful and you maintain your patent, you know there's someone else out there who is interested in your technology and specifically your patent. So that could be a potential licensee, but that's quite a specific use case. And exploring the other commercial opportunities, I mean, it's like any other business. Do I really need a patent attorney agent, or can I file it myself? So I'm a patent attorney, so you can probably guess what my answer is. And to put it into context, it takes many years to become a patent attorney and understand and become experienced and be able to write and draft a patent application well. I mean, you could flip it around and say, can I diagnose myself rather than going to the doctor? I mean, it's a similar thing. It's a professional process. And the thing about patents is it's detail orientated. There's lots of detail in the process of writing the application. There's lots of detail in the application process. It's a really process orientated and detail orientated part of law. So it isn't easy. I mean, I'm sure some people will want to file by themselves, and that may make sense on the face of it. It's cheaper. But the thing is, you're going to have to spend a lot more money in the process, working probably with a patent attorney to get your patent application to grant, or rewriting it and putting it in a good shape in the first place. So it's probably better and cheaper if you get it right first time with a patent attorney. But I would always say that because I'm a patent attorney. Okay, how do I respond to a 102, 103 rejection? What counts as obvious? Okay, this is a question which is using US patent terminology. In Europe, we might say a novelty or inventive step objection. Essentially, what happens when you file your patent application, it goes to the patent office, and a patent examiner will look at it and review it, and they will look at your idea, your patent, in the context of what's been done before. So a patent examiner is looking at your patent application and seeing what's the closest thing that's been done before, and is that different? So one, is it the same? If it's the same, the patent examiner is going to say it's not novel. And if there's a difference, they might say it's obvious, or in the US, or not inventive, what we'd say in Europe. And then it's a question of, well, do you need to respond to the examiner? Can you overcome that with arguments alone? Or do you need to make amendments to your application to refine or narrow the scope? And then you're essentially into a discussion with the patent examiner, perhaps a very long, protracted negotiation, but you're trying to persuade the examiner by presenting arguments and narrowing your scope to convince the examiner that you do have an invention. So will talking to manufacturers, customers, investors under an NDA protect me? Okay, interesting question. I think what this is asking is that, will that discussion with a manufacturer or an investor affect the patent application? So an NDA is also known as a non-disclosure agreement or a confidentiality agreement. And the purpose of that is essentially an agreement or a contract between two parties. So here it would be the inventor and the manufacturer. And if both parties sign it, it means both parties agree to keep the subject matter of that discussion confidential. And that means that that discussion can't be used to challenge the novelty of the subsequently filed patent application. And so the answer is yes, it will protect you. But again, I'm a lawyer, I'm going to qualify this a little bit. What it won't protect you against is third parties independently coming up with this idea. Or if there's, and that means that potentially there is a risk that if you're solely relying on NDAs, you may not be able to patent the concept if the information is out in the public domain. Okay, here's a good question. Is there such a thing as a worldwide patent? And what is the PCT? So the short answer to this is no. There's no such thing as a worldwide patent. And the reason is patents are granted on a country-by-country basis. The patenting system is essentially related to the law of the country. So you can get a US patent, you can get a UK patent, or a French patent. But there's no such thing as a worldwide patent. To get a worldwide patent, you'd have to go through every single country in the world, applying and registering. But because that has such a high cost and administrative burden, no one does it. But the patenting process is complicated, and there's a lot of process involved, and it takes a lot of time. So a lot of countries came together and tried to see if they could work a more streamlined process. And the result of that was something called the PCT, or the Patent Cooperation Treaty. And essentially this is a streamlined patent application process that allows applicants to more easily apply it across the world. And so resulting from a PCT application is easier to apply in the US, Europe, and other places in the world. You don't have to use the PCT process, but it is a lot of applicants do because it makes the process easier. Here's a question: how long does it take to get a patent? I could give an annoying answer like how long's a piece of string, but I can give you a bit more specifics about that. You need to think in the timescale of years. Unfortunately, patents aren't a quick process. There are some IP rights that are quick, but patents tend to take years. And I can give an explanation of the timeline so you can get a better understanding. So you file a patent on day 0. At 12 months, you may extend that protection to other countries using a patent application in the PCT process. At 18 months, your patent application will grant. And then you're into a process after filing the patent application, use your discussion with the patent examiner. And depending on how many rounds of correspondence you have with a patent examiner, it can take probably between, let's say, your first application probably 2 years. If you go through the PCT process and then file a US application or European application, it could be 4 or 5 years before all the applications in the patent family are granted. The question is, what if someone is already selling something similar? Am I infringing? Can I still patent? It's an interesting question, and it goes to one of the core concepts of patents. So if someone's already selling something similar, are you infringing? Well, the question really is, do they have a patent? So do they have a patent? You'd need to check. And then you need to check the claims of that patent against your product that you propose to sell. And if your product had all the features that were described in the claim of that granted patent, then yes, potentially you would be infringing. I say potentially because I am a lawyer, but I'm not your lawyer. So it's important on that respect. You need to speak to a professional patent attorney in questions of infringement, because it's not simple, and often there are shades of grey about whether you infringe a third party's patent or not. The other half of the question was, can I still patent? And this is an interesting question as well, because the answer is yes, but it depends on what you're trying to patent. If your product has an improvement above and beyond the similar product, say your product does something in a better or more efficient way, then that, assuming it's new and it's assuming the patent examiner deems it to be inventive, then yes, that could be patentable. If your product is already on sale and you haven't patented, then that might be problematic, but it would depend on the facts of the case. Utility patent versus design patent, which one do I need, or both? It's a great question. Probably to answer that, we need to dig in a little bit with what we mean by these different terms. So a utility patent covers inventions and improvements to a product or process, so more to do with the technology. A design patent covers the aesthetic appeal, the look of something. And which one do I need, or both? Well, it would depend on what your business is. And so if you're more deep tech and focused on the functionality, then utility patents are probably more appropriate. But if you're more into consumer products where you have technology and maybe the look of something is important to your consumers, then design patents are also important. It's important here to say that design patent and utility patent are terminology used in the USA, but there are similar rights in Europe and elsewhere in the world. So in Europe, we call design patents registered designs, and we call utility patents patents. Can I patent an improvement to someone else's patented product? The short answer is yes. So in fact, the whole patenting system is based upon that premise. So you can create an invention and it gives you an advance in technology. So I used an example yesterday of a soda can, and we were talking about the concave bottom of a soda can. So if this is your concept, then you could protect that. But at the same time, someone could have protected the concept of the ring pull at the top. And so you can have two different features in one product or one concept, which can be separately protected by different patents. So that means you can improve on a product, you can improve on someone's patented concept and patent that itself. A patent is protecting something new and something that is inventive. And if the concept has those two qualities, then yes, you can protect it with a patent. All right, here's another question. What exactly are maintenance fees and what happens if I miss them? So a maintenance fee might also be known as a patent renewal or a patent annuity. And once your patent is granted, in order to keep it in force, you have to pay the patent office a fee. Sometimes it's annually. So for example, in Europe, it's often annually. Sometimes it might be more periodic. So in the US, it's every 4 years. So what happens if you miss them? Your patent will be abandoned and you won't be able to use it. Sometimes there are periods where there's a late period, so you can still pay the fee with a late fee. And sometimes there are periods where you can still re-establish the patent, but often there's a very high bar and you have to prove that mistakes were made and you took all due care. And that's a really tricky process. So the patent maintenance fees, you have to be really careful with them, and often companies will outsource this to particular service providers, and then you can relax knowing that someone is handling this for you. We provide the service at Lightbringer, so you don't have to worry about paying your own maintenance fees or patent annuities. But yeah, if you're doing it yourself, you need to make sure that date's in the diary. How do I do a prior art or patentability search myself? So patents, patent applications and granted patents are published. That means there are public databases that you can go off and search. And normally you can search those databases with Boolean type searching. So using keywords searches, so things like laptop and screen, for example. Anyone can access those, so that's a good way of doing a first filter. I've also written a blog about this, how to do a novelty search, so feel free to go and look for that on the Lightbringer website. The other thing is to note that patents have lots of terminology that aren't necessarily familiar or everyday use. So patent searching is a specialized profession, and there are experts who are well versed in doing the patent searches. And at Lightbringer, we can help you with that. And we use AI-enabled searching tools to provide you a good understanding of whether your invention is novel or not. Do I really need a patent attorney, or can I do it myself? Okay, I'm a patent attorney, and I obviously feel very strongly about this. And the reason is I want you as an inventor to get it right first time, because the reason is it's going to be better and it will be cheaper for you in the long run. Because if you do it yourself, there will be things that creep in, and it will mean that you'll probably have to go to a professional to fix it anyway. And so it's much better to get it right first time. It is possible to get a patent granted if you do it yourself, but the thing is, you're not going to get the best protection because you don't know what's possible. You're relying on a patent examiner to kind of guide you in the process, and you need someone to advocate for your rights. But here at Lightbringer, it's really important to us that we're democratizing patents and sharing the information and making the patenting process easier. So we have a platform where you can interrogate your patents and ask questions about your patents and get real-world plain English answers. And also we have the support team like myself, patent attorneys, to help you, guide you through the process. So whilst you won't be doing it yourself, you can do a lot of it yourself. And we feel that makes things easier, and our customers seem to love it. Can I patent a name or a logo? The answer is no, but it doesn't mean you can't protect a name or a logo. So in intellectual property, there are different IPR, intellectual property rights, that protect different things. So names and logos are protected by trademarks. So you can register a trademark for a name or a logo, but patents protect technology, so improvements to a product or a process. What happens after I file my patent application? What if I miss the 12-month deadline? Once you've filed a patent application, there's an opportunity to extend protection to other countries at 12 months. It's also known as the 12-month priority period. And you might hear patent attorneys saying you can claim priority, which means you can use the same subject matter in the earlier application that you file in the different countries, so long as it's the same invention, same owner, same. So it's essentially, there's a similarity between those documents, and you can only do that up to 12 months. If you miss this 12-month date, then you can't claim priority and you can't extend that protection to other countries. So it really is important that you pay attention to this date and you make that decision. If you want to extend protection to other countries, you let the patent attorney know well in advance. Okay, I've got another question here. An old patent has expired. Can I commercialize it? This is a really interesting question because it goes to kind of the core of what a patent is. So the patent is a right for the owner of the patent to prevent other people from using their technology, a negative right. And that's a time-limited monopoly to a maximum of 20 years. So that means there's a period of time when a patent is no longer enforceable. The owner can't use it to stop someone else. So at that point, anyone can use the technology without fear of infringing that patent. There might be other patents out there that are relevant to whatever you're doing, but essentially if a patent is expired, then anyone can use that technology. And that's the whole point of the patent system. It's about the sharing the information and technology so everyone can improve on it and make new inventions.
Right.
Okay. Do you want this a short one or a long one?